Question 1. In a case where multiple parties have different objectives, a state legislature enacts a new voter ID law requiring all voters to present a state-issued identification before casting a ballot. A civil rights group challenges the law, arguing that it disproportionately affects low-income and minority voters who may have difficulty obtaining such identification. The state argues that the law is necessary to prevent voter fraud. Under current Supreme Court precedent, which of the following is the most likely legal outcome? A. The law is upheld because the government has a compelling interest in preventing voter fraud and the burden on voters is minimal. B. The law is struck down because it imposes a significant burden on minority and low-income voters, violating the Voting Rights Act of 1965. C. The law is invalidated because voting is a fundamental right and any restriction must pass strict scrutiny, which this law fails. D. The law is upheld. States have broad discretion over election procedures and there is no requirement to prove actual voter fraud. Answer A. The law is upheld because the government has a compelling interest in preventing voter fraud and the burden on voters is minimal. Explanation. This question examines voting rights and constitutional law, particularly under Crawford v. Marion County Election Board, 2008, where the Supreme Court upheld Indiana's voter ID law. Option is correct because the court has recognized voter ID laws as legitimate means to prevent voter fraud, even if no widespread fraud has been proven. The burden on voters is considered minimal, especially if the state provides free IDs. Option B is incorrect because while the Voting Rights Act of 1965 prohibits racial discrimination, voter ID laws have been upheld unless plaintiffs can show clear discriminatory intent. The court has often ruled that disparate impact alone is not enough. Option C is incorrect because not all voting restrictions require strict scrutiny. Courts use the Anderson-Burdick balancing test, weighing the burden on voters against the state's interest. Option D is incorrect because while states do have discretion, courts require rational basis for election laws. If the burden on voters were found excessive, the law might be struck down. Question 2. During a major transformation where existing methods are challenged, a public university implements race-conscious admissions policies to increase diversity. A group of applicants who were denied admission file a lawsuit claiming the policy violates their equal protection rights under the 14th Amendment. Given recent Supreme Court rulings, how is the court most likely to rule? A. The policy is unconstitutional because any racial classification in admissions violates the 14th Amendment's Equal Protection Clause. B. The policy is upheld if the university can prove that race-neutral alternatives were insufficient to achieve diversity. C. The policy is unconstitutional because it places an undue burden on applicants who are not members of the preferred racial groups. D. The policy is upheld because public universities have broad discretion in creating admission standards. Answer. B. The policy is upheld if the university can prove that race-neutral alternatives were insufficient to achieve diversity. Explanation. This question covers affirmative action and equal protection under cases such as Grutter v. Bollinger, 2003, and Fisher v. University of Texas, 2013, as well as the more recent Students for Fair Admissions v. Harvard, 2023. Option A is incorrect because the Supreme Court has upheld narrowly tailored race-conscious admissions programs if they serve a compelling interest in diversity. Option B is correct because the university must show that race-neutral alternatives, e.g., socioeconomic-based admissions, were insufficient before using race-conscious policies. This aligns with the Supreme Court's strict scrutiny standard. Option C is incorrect because burden alone is not enough to make policy unconstitutional. The court evaluates whether the policy is narrowly tailored to serve compelling interest. Option D is incorrect because while universities have discretion, they must comply with constitutional limits on race-based classifications. Question 3. While managing a hybrid approach where timing issues affect due process, a city enacts a policy allowing police officers to conduct stop and frisk procedures in high-crime areas based on reasonable suspicion. Civil rights advocates argue that this practice disproportionately targets racial minorities, violating the 4th and 14th Amendments. What legal principle is most relevant in determining whether this policy is constitutional? A. The Terry v. Ohio 1968 standard, which allows brief stops based on reasonable suspicion but requires that searches be limited in scope. B. The Graham v. Connor 1989 standard, which determines whether law enforcement use of force is reasonable under the 4th Amendment. See the Miranda v. Arizona 1966 ruling, which requires police officers to inform individuals of their rights before any questioning. D. The Brown v. Board of Education 1954 decision, which established the principle of equal protection under the law. Answer A. The Terry v. Ohio 1968 standard, which allows brief stops based on reasonable suspicion but requires that searches be limited in scope. Explanation. This question deals with Fourth Amendment search and seizure protections, particularly in the context of racial profiling. Option is correct because Terry v. Ohio 1968 established that police officers can stop individuals if they have reasonable suspicion of criminal activity, but frisks must be limited to detecting weapons. Courts have evaluated whether stop and frisk disproportionately impacts minorities, raising equal protection concerns under the 14th Amendment. Option B is incorrect because Graham v. Connor 1989 applies to excessive force claims, not stop and frisk policies. Option C is incorrect because Miranda v. Arizona 1966 applies to custodial interrogations, not pre-arrest stops. Option D is incorrect because Brown v. Board of Education 1954 relates to school segregation, not policing policies. Question 4. In a high-stakes environment where multiple challenges intersect, the principle of equal protection under the 14th Amendment is tested in modern voting rights cases. The state legislature enacts a law requiring all voters to provide a specific form of government-issued identification before casting a ballot. Critics argue that this law disproportionately affects low-income voters, elderly citizens, and racial minorities. The state, however, just the law as a necessary measure to prevent voter fraud, given Supreme Court precedent. Which of the following best describes how a court would analyze the constitutionality of this law? A. The court will apply strict scrutiny, requiring the state to prove that the law serves a compelling interest and is narrowly tailored. B. The court will apply rational basis review, requiring the law to be rationally related to a legitimate state interest. C. The court will apply intermediate scrutiny, requiring the state to show the law is substantially related to an important government objective. D. The court will not review the law as state exclusive authority over election procedures. Answer A. The court will apply strict scrutiny, requiring the state to prove that the law serves a compelling interest and is narrowly tailored. Explanation. The Equal Protection Clause of the 14th Amendment ensures that laws affecting fundamental rights, such as the right to vote, are subject to strict scrutiny if they disproportionately impact specific groups. In Harper v. Virginia Board of Elections, 1966, the Supreme Court ruled wealth-based restrictions on voting violate equal protection. Similarly, in Crawford v. Marion County Election Board, 2008, the court upheld Indiana's voter ID law, but only after considering evidence of its impact. If voter ID law is found to disproportionately disenfranchise protected groups, it must serve compelling government interest, such as preventing voter fraud, and be narrowly tailored to avoid unnecessary burdens. If the law is overly broad and affects specific class unfairly, courts may strike it down. Question 5. While investigating a complicated issue between different sectors, Congress considers passing an amendment to the Civil Rights Act of 1964 to extend workplace protections to independent contractors. Under current law, which of the following is the primary legal reason why independent contractors are generally not covered under Title VI's anti-discrimination provisions? A. The Civil Rights Act of 1964 explicitly excludes independent contractors from its protections. B. The Supreme Court has ruled that anti-discrimination protections only apply to public sector employees. C. Courts interpret the employee under Title Roman or common law agency principles, which generally exclude independent contractors. D. The Fair Labor Standards Act (FLSA) provides the exclusive framework, workplace anti-discrimination laws, and it does not cover independent contractors. Answer. C. Courts interpret the employer under Title Roman common law agency principles, which generally exclude independent contractors. Explanation. Title Omen of the Civil Rights Act of 1964 prohibits discrimination in employment based on race, color, religion, sex, and national origin. However, courts have consistently ruled that Title Roman protections apply only to employees and not independent contractors. The Supreme Court in Nationwide Mutual Insurance Company v. Darden 1992 established that common law agency principles, such as the right to control work performance, determine employment status. If worker is classified as an independent contractor having control over how they work, setting their hours and using their own resources, they typically fall outside Title Omanut protections. However, misclassification of employees, independent contractors has become key issue in civil rights and labor law. Question 6. During a comprehensive review of a process that needs improvement, a city government is accused of racial discrimination in housing policy after refusing to issue permits for multifamily housing in predominantly white neighborhoods. A civil rights lawsuit is filed under the Fair Housing Act (FHA) alleging disparate impact discrimination. What must plaintiff prove to prevail under disparate impact claim? A. That the city officials had discriminatory intent when enacting the policy. B. That the housing policy has disproportionately adverse effect on racial minorities, even without proof of intent. C. That the policy violates the Equal Protection Clause of the 14th Amendment. D. That private landlords within the city are also engaging in discriminatory practices. Answer B. That the housing policy has a disproportionately adverse effect on racial minorities, even without proof of intent. Explanation. Under the Fair Housing Act (FHA) of 1968, disparate impact claims arise when a policy disproportionately affects a protected class, even if no discriminatory intent is proven. In Texas, Department of Housing and Community Affairs v. Inclusive Communities Project, 2015, Supreme Court upheld that disparate impact claims are valid under the FHA if statistical evidence shows a policy disproportionately harms racial minorities or other protected groups. Unlike intentional discrimination claims, plaintiffs do not need to show explicit bias, only that the policy results in significant racial disparities. If plaintiff establishes disparate impact, the government must prove legitimate, non-discriminatory justification, which must be the least discriminatory alternative available. Question 7. When implementing new protocols in a shared environment, a police department adopts new guidelines allowing officers to conduct random pedestrian stops in high-crime neighborhoods. Civil rights advocates argue that this policy disproportionately targets racial minorities. Which legal principle is most relevant in determining whether this practice violates the 4th and 14th Amendments? A. The totality of the circumstances test for reasonable suspicion under Terry v. Ohio. B. The state action doctrine, which requires discriminatory intent for constitutional violations. C. The fundamental rights doctrine, which guarantees freedom from all police searches without probable cause. D. The exclusionary rule, which automatically voids any evidence obtained from an unconstitutional search. Answer A. The totality of the circumstances test for reasonable suspicion under Terry v. Ohio. Explanation. Under the 4th Amendment, law enforcement officers must have reasonable suspicion to stop and search individuals. The landmark Supreme Court case Terry v. Ohio, 1968, established that brief stops and frisks are constitutional if based on specific and articulable facts leading a reasonable officer to believe that person is engaged in criminal activity. However, racial profiling concerns have led courts to scrutinize whether such policies disproportionately impact racial minorities, raising Equal Protection Clause issues under the 14th Amendment. Courts examine whether a stop and frisk policy unfairly targets specific racial groups without legitimate justification. If plaintiffs prove a pattern of racial disparities in how the policy is enforced, courts find an equal protection violation. Question 8. In a large organization where multiple departments need to coordinate, a public university implements an admissions policy that considers race as one factor in a holistic review process. Opponents argue that this violates the Equal Protection Clause of the 14th Amendment, which of the following best describes the constitutional test applied to this policy? A. Rational basis review, as educational institutions have broad discretion in admissions policies. B. Strict scrutiny, requiring the university to prove the policy is narrowly tailored to achieve a compelling interest. C. Intermediate scrutiny, as race-based classifications in education require an important government interest. D. The undue burden test, which applies to policies that create significant obstacles to fundamental rights. Answer. B. Strict scrutiny, requiring the university to prove the policy is narrowly tailored to achieve a compelling interest. Explanation. Race-based classifications in public education are subject to strict scrutiny, the highest level of judicial review under the Equal Protection Clause of the 14th Amendment. The Supreme Court has ruled in cases like Grutta v. Bollinger, 2003, and Fisher v. University of Texas. 16. That diversity in higher education is a compelling government interest, but any race-conscious admissions policy must be narrowly tailored to achieve that goal. Universities must show that no race-neutral alternatives would achieve the same diversity benefits. Question 9. During a critical transition period where existing processes are under scrutiny, a city passes a law prohibiting individuals from sleeping in public spaces. Homeless advocates argue this violates the Eighth Amendment's protection against cruel and unusual punishment. How have courts typically addressed such claims? A. The law is unconstitutional because it criminalizes persons' status rather than conduct. B. The law is constitutional if the city provides sufficient alternatives, such as shelters. C. The law is permissible under police power, as municipalities have broad authority over public spaces. D. The law is valid unless it can be shown that it disproportionately impacts protected class. Answer. A. The law is unconstitutional because it criminalizes a person's status rather than conduct. Explanation. In Martin v. City of Boys 2018, the Ninth Circuit ruled that punishing individuals for sleeping in public spaces when no alternative shelter is available violates the Eighth Amendment. The court found that laws criminalizing homelessness as status rather than specific conduct constitute cruel and unusual punishment. Cities can enforce such laws if adequate shelter options exist. Question 10. When dealing with a complex system that shows occasional failures, a federal agency revises its hiring practices to require applicants to disclose past felony convictions. Civil rights groups argue this has a discriminatory effect on racial minorities. Under Title Roman of the Civil Rights Act, which legal standard applies to evaluate this claim? A. Strict scrutiny, as the policy involves classification based on criminal history. B. Disparate impact analysis, requiring proof that the policy disproportionately affects protected groups. C. Rational basis review, as employment policies are generally at the employer's discretion. D. Fundamental rights doctrine, as employment is basic right protected under the Constitution. Answer. B. Disparate impact analysis, requiring proof that the policy disproportionately affects protected groups. Explanation. Title Roman of the Civil Rights Act of 1964 prohibits employment practices that have a disparate impact on protected groups, even if they appear neutral. In Griggs v. Duke Power Company, 1971, the Supreme Court ruled that employers must justify policies that disproportionately exclude racial minorities by showing they are job-related and necessary. Blanket bans on applicants with criminal records can disproportionately impact Black and Latino applicants, requiring employers to demonstrate a legitimate business necessity. Question 11. In a high-stakes environment where multiple challenges arise, the state enacts a law banning certain books from public school libraries based on their content. Civil rights groups challenge the law under the First Amendment. What is the key legal question in determining the constitutionality of this law? A. Whether the banned books contain political speech, which is highly protected under the First Amendment. B. Whether the ban is content-based and subject to strict scrutiny. C. Whether students have a fundamental right to access any book of their choosing. D. Whether the law imposes an undue burden on free speech. Answer. B. Whether the ban is content-based and subject to strict scrutiny. Explanation. Content-based restrictions on speech are subject to strict scrutiny under the First Amendment. In Board of Education v. Pico 1982, the Supreme Court ruled that public schools cannot remove books from libraries solely based on disapproval of ideas. However, schools have some discretion over library content, provided decisions are based on educational suitability rather than ideology. Question 12. While investigating a complicated issue between different sectors, a state legislature passes a law requiring businesses to provide gender-neutral restrooms. Opponents challenge the law under the 14th Amendment. Which legal principle will most likely be used to evaluate the challenge? A. Rational basis review, as gender-neutral policies do not target a suspect class. B. Intermediate scrutiny, as gender-based distinctions are involved. C. Strict scrutiny, as access to public accommodations is a fundamental right. D. The balancing test, weighing privacy concerns against public interest. Answer. A. Rational basis review, as gender-neutral policies do not target a suspect class. Explanation. Laws requiring gender-neutral accommodations do not discriminate against or favor a particular group and are typically upheld under rational basis review. Courts generally find that states have a legitimate interest in ensuring equal access to public spaces, but such laws are rarely subjected to heightened scrutiny unless they specifically burden a protected class. Question 13. During a comprehensive review of a process that needs improvement, a local government adopts an affirmative action policy in public contracting. A lawsuit is filed alleging reverse discrimination. How will a court analyze the constitutionality of the policy? A. Under strict scrutiny, requiring the government to show a compelling interest and narrow tailoring. B. Under rational basis review, as affirmative action policies are discretionary. C. Under intermediate scrutiny, as economic policies receive heightened review. D. Using the disparate impact standard, requiring statistical evidence of discrimination. Answer: A. Under strict scrutiny, requiring the government to show a compelling interest and narrow tailoring. Explanation: race-based affirmative action policies in government contracting are reviewed under strict scrutiny per City of Richmond v. J.A. Cross and Ompany, 1989. Governments must show a compelling interest in remedying past discrimination and that the policy is narrowly tailored to that interest. Question 14. When implementing new protocols in a shared environment, a school district introduces a dress code banning religious head coverings. A Muslim student challenges the policy under the First Amendment. What is the strongest argument against the dress code? A. It violates the free exercise clause by restricting religious expression. B. It violates the establishment clause by favoring secularism. C. It imposes a prior restraint on symbolic speech. D. It is overly broad, impacting all students. Answer: A. It violates the free exercise clause by restricting religious expression. Explanation: the free exercise clause of the First Amendment protects religious practices including wearing religious head coverings. In Tinker v. Des Moines, 1969, the court ruled that students do not lose their constitutional rights at the schoolhouse gate unless the policy serves a compelling interest and is narrowly tailored. It is likely unconstitutional. Question 15. In a scenario where efficiency decreases across multiple departments, a city council passes a law requiring all contractors to use union labor for public projects. A non-union contractor challenges the law, claiming it violates the National Labor Relations Act (ARI). What is the strongest legal argument against the requirement? A. The law violates the Commerce Clause by restricting free trade between states. B. The law conflicts with federal labor laws, making it preempted by the ARA. C. The law violates the First Amendment by compelling speech through forced union dues. D. The law is unconstitutional under the Equal Protection Clause due to disparate treatment. Answer: B. The law conflicts with federal labor laws, making it preempted by the ARA. Explanation: under the Supremacy Clause, federal laws like the ARA preempt conflicting state or local regulations. The Supreme Court has ruled that states cannot interfere with labor relations governed by federal law. Chamber of Commerce v. Brown, 2008. A law requiring union labor effectively restricts non-union businesses could be seen as infringing upon rights protected by federal labor statutes. Question 16. While analyzing the root causes of sequential problems in regulatory compliance, a federal agency increases fines for non-compliance without allowing public comment. A business challenges this decision, claiming it violates administrative law. What legal doctrine is most relevant in this case? A. The major questions doctrine, as the agency is making a policy change with significant economic impact. B. The Chevron doctrine, which defers to agency interpretation of statutes. C. The non-delegation doctrine, which prevents Congress from giving broad powers to agencies. D. The Administrative Procedure Act, a power which requires public participation in rulemaking. Answer: D. The Administrative Procedure Act, a power which requires public participation in rulemaking. Explanation: the Administrative Procedure Act, a power mandates that federal agencies must allow public comment before implementing new rules. 5 U.S.C. SS 553. In cases like Motor Vehicle Manufacturers Association v. State Farm, 1983, courts struck down agency actions for failing to follow notice and comment requirements. If the agency failed to provide an opportunity for feedback, the policy could be overturned. Question 17. In a case where multiple parties have different objectives regarding land use, the state government seizes private property for economic redevelopment. The property owners argue this violates the Fifth Amendment's Takings Clause. What Supreme Court case is most relevant? A. Kelo v. City of New London, 2005, which allowed takings for economic development. B. Lucas v. South Carolina Coastal Council 1992, which prohibited takings without compensation. C. Dolan v. City of Tigard 1994, which set limits on exactions in land use permits. D. Nolan v. California Coastal Commission 1987, which required an essential nexus in use conditions. Answer A. Kelo v. City of New London 2005, which allowed takings for economic development. Explanation in Kelo v. City of New London 2005, the Supreme Court ruled that the government can take private property for public use if it serves a public purpose, even for economic development. This decision remains controversial as it expanded the definition of public use under the Fifth Amendment's clause. However, many states later passed laws limiting eminent domain powers. Question 18. During a major transformation where existing methods are outdated, a new law requires social media platforms to remove harmful content. Opponents argue this law violates the First Amendment. What legal principle will most likely be used to analyze the law? A. Content neutrality, which prohibits restrictions based on subject matter. B. The public forum doctrine, which applies to speech in government-controlled spaces. C. Prior restraint, which prevents censorship before speech occurs. D. The overbreadth doctrine, which invalidates laws that restrict more speech than necessary. Answer A. Content neutrality, which prohibits restrictions based on subject matter. Explanation. Under First Amendment jurisprudence, laws regulating speech must be content neutral unless they pass strict scrutiny. In Reno v. Clue 1997, the court struck down the Communications Decency Act because it broadly restricted online speech. Courts often rule that the government cannot dictate what platforms must remove unless it involves illegal content like threats or obscenity. Question 19. When implementing backup procedures across various agencies, a state requires government employees to disclose all personal digital communications. A lawsuit claims this violates the Fourth Amendment. What legal issue is most relevant? A. The expectation of privacy in digital communications. B. The chilling effect on free speech. C. The public records doctrine. D. The rational basis test for privacy concerns. Answer A. The expectation of privacy in digital communications. Explanation. In Carpenter v. United States 2018, the Supreme Court ruled that individuals have a reasonable expectation of privacy in digital records. If the government requires employees to disclose private communications, it could be considered an unreasonable search and seizure under the Fourth Amendment unless supported by legitimate security concerns. Question 20. While updating traditional approaches where interconnections matter, a state passes a law restricting the use of artificial intelligence in hiring decisions. Businesses argue this violates the Commerce Clause. What is the strongest argument for their claim? A. The law discriminates against out-of-state companies. B. The law imposes an undue burden on interstate commerce. C. The law restricts speech and violates the First Amendment. D. The law conflicts with federal employment guidelines. Answer B. The law imposes an undue burden on interstate commerce. Explanation. Under the Dormant Commerce Clause, states cannot pass laws that excessively burden interstate commerce. Pike v. Bruce Church, Inc., 1970. If a law prevents companies from using AI across state lines, it could be struck down as an undue burden on interstate business activities. Question 21. In an environment where different components must interact, a new federal agency regulation limits workplace surveillance. A technology company challenges it, arguing the agency exceeded its authority. Which doctrine applies? A. The Chevron doctrine, which defers to agency interpretations. B. The Major Questions doctrine, which limits agency power in significant policy areas. C. The Equal Protection Clause, which applies to workplace regulations. D. The Non-Delegation doctrine, which restricts legislative power transfers. Answer B. The Major Questions doctrine, which limits agency power in significant policy areas. Explanation. In West Virginia v. EPA 2022, the Supreme Court ruled that agencies cannot regulate major economic and political issues without clear congressional authorization. If workplace surveillance is deemed a major policy issue, courts may require explicit legislative approval before the agency can enforce regulations. Question 22. During an emergency response where multiple areas are impacted, a governor issues an executive order restricting public gatherings. A lawsuit argues this violates the First Amendment. How will the court likely analyze the claim? A. By applying strict scrutiny, as the order limits fundamental rights. B. By using the rational basis test, as public safety is a legitimate concern. C. By deferring to executive power during emergencies. D. By applying intermediate scrutiny, balancing rights and government interest. Answer: A. By applying strict scrutiny, as the order limits fundamental rights. Explanation: restrictions on public assemblies and speech trigger strict scrutiny under the First Amendment. Roman Catholic Diocese v. Cuomo 2020. While governments can impose restrictions for public safety, they must be narrowly tailored and least restrictive to achieve their goal. Question 23. In a scenario where efficiency decreases across multiple departments, a state enacts a law requiring all businesses to use only domestically produced materials. A company challenges this law, claiming it violates the Commerce Clause. What is the strongest argument against the law? A. The law discriminates against interstate commerce by favoring in-state businesses. B. The law violates the Due Process Clause by imposing arbitrary restrictions. C. The law fails the strict scrutiny test under the Equal Protection Clause. D. The law is permissible under the state's police powers. Answer: A. The law discriminates against interstate commerce by favoring in-state businesses. Explanation: under the Dormant Commerce Clause, states cannot pass laws that discriminate against out-of-state commerce or unduly burden interstate trade. Granholm v. Heald 2005. If a state forces companies to buy local materials, it restricts competition and likely violates constitutional protections against economic protectionism. Question 24. While analyzing the root causes of sequential problems in regulatory compliance, a federal agency bans a company from producing a product without holding a formal hearing. The company argues this violates due process. Which constitutional principle is at issue? A. Procedural due process, which requires notice and a hearing before government action. B. Substantive due process, which limits government interference with fundamental rights. C. The major questions doctrine, which limits agency power over significant issues. D. The rational basis test, which applies to economic regulations. Answer: A. Procedural due process, which requires notice and a hearing before government action. Explanation: under the 5th and 14th Amendments, the government must provide notice and an opportunity to be heard before depriving a person or business of property rights. Matthews v. Eldridge 1976. If an agency bans a product without a fair hearing, it likely violates procedural due process. Question 25. In a case where multiple parties have different objectives regarding land use, a city requires property owners to install public sidewalks as a condition for new construction. A developer challenges this requirement. What is the strongest legal argument against the city's rule? A. The requirement violates the Takings Clause unless just compensation is provided. B. The requirement violates the First Amendment as compelled speech. C. The rule exceeds the city's police powers under the 10th Amendment. D. The regulation is valid under the rational basis test. Answer: A. The requirement violates the Takings Clause unless just compensation is provided. Explanation: under Dolan v. City of Tigard 1994 and Nolan v. California Coastal Commission 1987, governments cannot require property owners to make improvements unless there is a direct connection, essential nexus, between the requirement and the development's impact. If the city forces property owners to build sidewalks with proper justification, it may be an unconstitutional taking. Question 26. During a major transformation where existing methods are outdated, a legislature enacts a new law banning certain artificial intelligence tools. The company sues, arguing the law is too vague. What legal doctrine is most relevant? A. The overbreadth doctrine, which invalidates overly broad laws. B. The vagueness doctrine, which prevents unclear legal standards. C. The rational basis test, which applies to non-fundamental rights. D. The major questions doctrine, which limits agency power. Answer: B. The vagueness doctrine, which prevents unclear legal standards. Explanation: the vagueness doctrine, established in Grain v. City of Rockford 1972, states that laws must be clear enough for individuals to understand what is prohibited. If a law banning AI fails to define key terms, it may violate due process under the 5th and 14th Amendments by being too vague to enforce fairly. Question 27. While updating traditional approaches where interconnections matter, a new law restricts how private companies collect biometric data. A business argues this interferes with their First Amendment rights. How will a court likely analyze the claim? A. The court will apply strict scrutiny, as biometric data collection involves speech. B. The court will apply intermediate scrutiny, balancing business rights and government interests. C. The court will likely reject the argument, as data collection is not protected speech. D. The court will apply rational basis review, as economic regulations receive minimal scrutiny. Answer C. The court will likely reject the argument, as data collection is not protected speech. Explanation: the First Amendment protects speech, but courts have ruled that the mere collection of data is not always a form of protected expression. Sorrell v. IMS Health, 2011. While restrictions on publishing or sharing data may implicate free speech, limiting data collection for privacy reasons is generally considered a permissible business regulation. Question 28. When implementing backup procedures across various agencies, a state law requires social media companies to store all user messages indefinitely. A lawsuit argues this violates the Fourth Amendment. What key precedent applies? A. Carpenter v. United States, 2018, which recognized digital privacy rights. B. United States v. Jones, 2012, which addressed GPS tracking and privacy. C. Katz v. United States, 1967, which established the reasonable expectation of privacy. D. All of the above. Answer: D. All of the above. Explanation: digital privacy cases, including Carpenter, Jones, and Katz, established that users have a reasonable expectation of privacy in their personal data. Requiring indefinite storage of private messages without user consent may be an unreasonable search under the Fourth Amendment. Question 29. In an environment where different components must interact, a new regulation bans independent contractors in certain industries, requiring all workers to be classified as employees. What is the strongest legal challenge to this law? A. The law violates the Equal Protection Clause by treating different industries differently. B. The law conflicts with federal labor statutes, making it preempted. C. The law violates the First Amendment by restricting economic speech. D. The law is unconstitutional under the Contracts Clause. Answer: B. The law conflicts with federal labor statutes, making it preempted. Explanation: the National Labor Relations Act (ARIT) and the Fair Labor Standards Act (FLSA) set federal standards for worker classification. If a state law contradicts these federal protections, it could be preempted under the Supremacy Clause. Chamber of Commerce v. Bonta, 2021. Question 30. During an emergency response where multiple areas are impacted, a governor issues an order suspending all gun sales. A challenge argues this violates the Second Amendment. What legal test will courts most likely apply? A. Strict scrutiny, as the regulation burdens a fundamental right. B. Intermediate scrutiny, balancing public safety and individual rights. C. The rational basis test, as public safety is a legitimate concern. D. The major questions doctrine, limiting executive power. Answer: B. Intermediate scrutiny, balancing public safety and individual rights. Explanation: under District of Columbia v. Heller, 2008, and McDonald v. Chicago, 2010, courts recognize that the Second Amendment protects individual gun rights. However, regulations on firearms, especially during emergencies, are often subject to intermediate scrutiny, meaning they must substantially relate to an important government interest like public safety.